So welcome everybody to the Body-Worn Cameras webinar. We are Division of Labor Services. I'm Mike Coviello. I'm the Associate General Counsel for the National Fraternal Order Police Division of Labor Services. And this webinar has been inspired by many questions that have been asked of us in recent months, and then also inspired by recent events that have made national headlines. I'm sure everybody's aware. The debate that is ongoing and will probably continue on for quite some time as to the value and necessity of body-worn cameras. A lot of these similarities in this debate harken back to GPS systems in cars and cameras in cars. So some of the same concepts exist, some of the same questions exist, and for those who already are using body-worn cameras, who have GPS systems in their cars, or car cameras, I'm sure have experienced some of these questions and have resolved them to one extent or another. Because this is a new technology and policies are being hammered out all over the country, there are as many questions as there are answers as this analysis continues. So we are pushing through this with some suggestions and some guidance and hopefully some answers. And we encourage the participation and input in this debate as we go forward, as we all figure out where this is going to end up. And when the dust settles, we're hoping that the value is more on the side of the protection of the officers and to the benefit of the officers as opposed to the other way around. A lot of the research that's been done in this area has been done by me and the staff of the Division of Labor Services, as well as Christina Coral, who's also an Associate General Counsel at our General Counsel's office in Columbus, and some input from Will Aitchison at LRIS. Those of you who are aware, we know that we have a very good relationship with LRIS and Will Aitchison, and we continue that relationship to everybody's benefit. We're going to talk about basic workplace privacy in the Fourth Amendment, what a body-worn camera is, the pros and cons of body-worn cameras, what management's concerns are, what officers' concerns are, and hopefully some suggestions. We are not in a position to offer any significant legal advice in this webinar. These are merely guides and suggestions, and as we always try to do, we deliver the best possible suggestions and guidance in going forward. The workplace privacy really started with the right to privacy back in 1967. Many of you are familiar with the U.S. v. Katz case, which involved the discussion of what an expectation of privacy is. It's a case that involved a suspect who was using a public payphone in a private conversation, and officers intercepted that conversation without a warrant in the Supreme Court. In analyzing what a citizen intends to keep private should be maintained as private as long as society is willing to accept the expectation of that individual as reasonable, and certainly a telephone call is one that falls within that realm. What does this have to do with what we're talking about? It's just a basic foundation of the right to privacy, and one of the biggest concerns that we have with these body-worn cameras is how does it affect the officer's individual right to privacy or an expectation of privacy, especially in the workplace. From there, in 1987, OConnor versus Ortega was also a Supreme Court case. This was the case that actually established what the expectation of privacy is in the workplace for a public employee, and it established the standard as opposed to a probable cause standard in a criminal case. It established a reasonable suspicion standard for workplace searches by employers. This was followed, that case followed the New Jersey versus TLO case, which made school student searches permissible based upon a reasonable belief of misconduct, which is how we came to the reasonable suspicion standard for workplace searches by employers. Also in this O'Connor versus Ortega case, Justice O'Connor created or for the first time discussed the operational necessity doctrine, basically stating that whatever an employee's expectation of privacy is in a workplace and whether or not the intrusion on that expectation is reasonable is based upon what the operational necessity of the employer is. In other words, the courts will balance what the operational necessity or mission of the agency is against an officer's expectation of privacy. And from that, we have basically developed this doctrine that the search or privacy expectations of an officer in a police agency is somewhat less significant than the expectation of privacy you might have in your own home. This is very significant in terms of our discussion of body-worn cameras because of the, obviously, the workplace operation of these body-worn cameras. The court has held that an office is seldom a private enclave, free from entry by supervisors and other employees. So in other words, the mere fact that your office is accessible to your employer and to other employees, and by the way, this often when we talk about office, we can talk about police cruisers, we can talk about your contact with citizens on a walking beat, etc. Essentially, the nature of government employee is such that your expectation of privacy is somewhat diminished as compared to other aspects of private life. And the court went on to say that requiring an employer to obtain a warrant whenever it wishes to enter an employee's office or workspace, desks, file cabinets, even lockers, could be unduly burdensome. And imposing that warrant requirement on employers would be contrary to operational necessity, and as it says at the bottom, would be simply unreasonable in the court's analysis. We take this further on when we look at other cases that the courts have decided. There is no expectation of privacy in an automobile traveling on public thoroughfares. Those of you who are actively engaged in traffic stops and searches of vehicles in your daily work are aware of this. The court in Phillips v. Township of Cumberland said that there's no expectation of privacy in a police cruiser, and this was a discipline case that stemmed from an officer who was on a private cell phone conversation with his girlfriend and was disciplined for being negligent in his duties because he wasn't attentive to his duties, driving his police cruiser engaged in a private conversation. The discipline was sustained in that case. I'm sorry that this keeps coming up. The court held that there is no expectation of privacy in a police cruiser when you're on duty. In Kwan versus City of Ontario, the court said that even though an employer, the City of Ontario, had stated that there would be no intrusion into the employee's text messages on their text pagers, and that they would be entitled to an expectation of privacy. When the bills came in for the text pagers, the chief went into the text messages to see if there were actually business texts that were being done as opposed to private, because they were going so far beyond their plan. And the testimony in court was that the chief was merely looking to see if these were actual business texts to determine whether or not the department needed a bigger plan. Several texts were found to be inappropriate and discipline ensued. The Supreme Court said that even though the department said that there would be an expectation of privacy in these texts, the search was not deemed to be unreasonable and the discipline was not reversed, because there was, at its inception, the search was not for disciplinary purposes, and that the discipline was merely incidental, which is quite frankly offensive, but this is the law that we have at this point, that the privacy in the workplace is essentially non-existent. In the Pennyfeather versus Tesler case, there's no expectation of privacy when you give your information to your employer. This was a case where a Social Security number audit was given, was done by the employer, and discrepancies were found in the individual's personnel file, which led to discipline. And the court said that when you voluntarily give your information to the employer, it's theirs to do with as they wish, with the exception of disclosing it to the public, as long as it's done for a business necessity. And the counter argument was, we have no choice but to give our Social Security numbers to the employer, and the court's response was, you have a choice not to work there. In Greenwald versus Indiana Department of Corrections, there was a fitness for duty evaluation that was ordered. The information was disclosed. The employee sued, and the court said it's not a Fourth Amendment analysis, it's an invasion of privacy claim, which would have been more appropriate. So in other words, the courts are withdrawing from Fourth Amendment type analysis in this particular case. In the case at the bottom, Calderola, the agency made arrests of employees for being engaged in corruption and intentionally paraded the defendants past the media, and there was a claim made that that was an unlawful seizure of the image for the purposes of defaming these people before they were convicted. The court said while there may have been a seizure of the image, the invasion of privacy was minimal and therefore not recoverable. In this particular case, Domain v. Samuels, the court said that a Fourth Amendment is not violated in a case where an agency specifically says you have no expectation of privacy in your vehicle, your desk, your personal vehicle when it's on agency property. The courts have routinely said over and over again, you only have an expectation of privacy where it's been guaranteed in some way, and where the agency goes out of its way to say you have no expectation of privacy and put you on notice that you have no expectation of privacy, the courts will not look for one or find one. This case is probably the most troubling of all of the privacy cases that I've looked at. In this Lynch versus NYPD, this is a Second Circuit case, 2013. This was a case where anytime there is a discharge of a firearm resulting in injury or not, then a breathalyzer test will be administered to the officer who discharged a firearm. The court said that this falls within the special needs exception to the Fourth Amendment. In this particular case, officer sued saying that, wait a second, we're trained to use our firearms, we discharge them in the course of our duty, and in doing so, you're now going to presume that there may have been some problem or disciplinary issue, and you're going to subject us to a breathalyzer test. The city's argument against that was, we are doing this to ensure the public's confidence that our officers in the conduct of their duties are not intoxicated. In essence, saying that there's a presumption that whenever an officer acts within the scope of their duties, that there may be some suggestion or suspicion that they may have acted improperly or may have been acting while they were in an intoxicated state, despite the fact that there was no evidence to support such a presumption or conclusion or suspicion. The court said that this falls within the special needs exception. The special needs exception came from the, you may be familiar with the Skinner Railroad case, where the courts held that when a locomotive or a train runs off the tracks, which is not something that would ordinarily happen, that something must have been done incorrectly. Therefore, it was within the dangerous instrumentality test to subject the train engineers to substance abuse testing. What I find offensive about this is when an officer discharges a firearm in the course of his duty in the way they've been trained to do it under the circumstances in which it's required, to presume that there's been something that's been done wrong is quite frankly offensive, because if a locomotive runs off the track, clearly that's not supposed to happen. But when an officer is faced with a situation where he or she has to discharge a firearm in defense of himself or others under the Graham versus Connor standard, which is the officer reasonably believes it's necessary, to then presume that there is some sort of potential for intoxication, quite frankly, flies in the face of all of that precedent. But this is what we're dealing with at this point in time. The courts are routinely looking for ways and getting around the expectation or right to privacy in a public employee. And all of this sets the stage for the debate that we're now going to enter into with body-worn cameras and how they're going to be used. With regard to body-worn cameras, there is very little case law to this point. The biggest linchpin in this debate began in 2013 under the New York City stop and frisk policy that's been under fire and constitutional attack for quite some time. Under this case, the judge ordered a pilot program where officers will wear body-worn cameras to ensure that they were not stepping outside of their constitutional limitations in their contacts with citizens. In Allen versus City of Oakland in 2012, in the middle of the Occupy Oakland protests, several officers were found to have turned off their lapel cameras while making arrests in violation of court order. The officers were disciplined, but fortunately not held in contempt by the court. This, again, sets the stage for how body cameras are going to be deployed and how they're going to be used. We have to balance in this discussion the potential for the invasion of privacy of the officer and the public versus deterring alleged officer misconduct, as well as false allegations against officers in their contacts with citizens. The big question is, when is the camera on? Will this be a continuously running apparatus, or will it be activated by the officer on based upon policy or necessity? And if it's a continuous run, does the technology even exist for a battery to last for 12 hours? Officers obviously do not want to be in a position to be accused of turning the cameras off, which would lead to their intentional commission of misconduct or their intentional abuse of a citizen's rights. However, if there's a continuous recording, it becomes a stressful and oppressive workplace environment for the officers. For example, in dealing with rest periods, contact with officers, contact with confidential informants. If you have a continuous on recording, what would happen if you were inside the home of someone who's been the victim of a violent crime, who does not want to be recorded, who has privacy concerns, dealing with juveniles, people walking down the street. And then once you have all of this data, all of this video, all of these recordings, what do you do with it? How are the departments supposed to store and keep this? Do the public records laws actually have a consideration for these types of questions? There obviously needs to be retention schedules that are developed to keep the video for short periods of time, for weeks, unless flagged for issues involving use of force, incidents that lead to arrest, or if there's been a citizen or other complaint filed about the encounter. And of course, you run into those concerns if the retention schedule is for, say, 6 weeks, and then 3 months later somebody comes in and files a complaint about a citizen contact. Now you have concerns about whether the video was intentionally deleted by the department in an effort to protect an officer or to protect itself or cover up some misconduct that was conducted by the officer, or in some arguments sanctioned by the department. Should officers be required to notify suspects or members of the public that they're being recorded on a body camera? Should the officers who enter private homes be required to notify the occupants of the camera, or give the occupants the opportunity to request it be shut off? One of the scenarios that comes to mind is a violent crime takes place in a neighborhood, and officers go in and they start interviewing neighbors who don't want to be made known to the public or be made known to the potential suspect that they are witnesses in the case and then exposed to danger or have those suspicions or concerns. When would the video footage be released to the public? When is it considered criminal intelligence? Is it considered an ongoing investigation? When the investigation is concluded, does the video become available to defense attorneys? Does it become available to the suspects themselves? How and when would public records requests make these particular videos available? Could the officers of the public object to the release of a video that does not involve a complaint or the use of force? These are questions that all have to be considered in formulating the policy, and in some cases the statutes that are going to deal with this. legislatures are well behind this curve. There are very few statutes that even have been drafted to deal with these particular questions, and certainly the technology. We've already talked about the sensitive witness statements or the sensitive victim statements. Would knowing that you're being recorded deter a suspect, a witness or a victim from actually even participating in the investigation? Now, there are clearly benefits to both the officer and the public when the body-worn cameras are used. Conspiracy and cover-up allegations will always play a role in our litigious society. There will always be those instances where the camera didn't work, the officer neglected to turn it on, circumstances arose that made it a safety concern or a distraction and therefore not turn it on. You have a situation where you have a controversial shooting, the camera didn't work or didn't record appropriately. Was that done intentionally? Transparency and accountability are always those slogan-like terms used in government services. And the thought that body-worn cameras will be the answer to all of those concerns is just quite simply not the case. Body-worn cameras will clearly not answer all of these questions and may in fact lead to more questions and different types of complaints or concerns or allegations of cover-up, and certainly will fuel a different debate. But the pros, obviously you have real-time evidence gathering, the efficiency of prosecution when you have actual real-time evidence gathered in the actual commission of an attack on a police officer, or police officers witnessing of a hand-to-hand transaction, for example, or an attack of a suspect on a citizen, and if it's caught on camera, clearly that will be of assistance. Internal affairs cases, the complaints that are coming from a citizen about a roadside stop that leads to a dispute between a citizen and an officer. Clearly those types of situations caught on camera will deter or at least potentially exonerate an officer, and we've seen some of that with car cameras. That clearly will lead to an efficient civil defense of officers and agencies. If an officer knows that everything that they're doing is going to be recorded in some fashion, whether it be audio or video, the argument that it will lead to increased professionalism, the impartial eyewitness, for example, that the video doesn't lie, the public trust. If there had just been some way to videotape or have some recording of the incidents that transpired recently between the officer and the citizen who got shot, that perhaps we wouldn't have riots or we wouldn't have the argument that the officer executed somebody. Those are always good arguments in favor of having the body-worn camera. If we had just had some way to verify the story one side or the other, it would not lead to such civil unrest, perhaps. The International Association of Chiefs of Police has done research on this, and they claim that in-car cameras, for example, have exonerated officers in 93% of the cases, that many complainants dropped their complaints upon learning that there was a video, and that only 5% of those complaints were sustained based upon the impact of the video evidence on those investigations. How they came to these numbers or what their research consisted of is not readily known, but this is what the International Association of Chiefs of Police claims. They also claim that in Rialto, California, that citizen conduct claims fell by 87.5% as a result of having cameras, and that there were 59% fewer incidents of use of force. I find these numbers to be pretty dramatic, and again, there's no way to verify these numbers, but this is what management is claiming on the Chiefs of Police side as to the efficacy of these cameras and how the value of them translates into the protection of police and the agencies in general. The cons. Clearly, when you're under the microscope constantly, you're made to feel as though you cannot be trusted, that you're not professional in some way, and that the presumption is, unless there's this camera rolling, that you will somehow not engage the public in a professional or courteous manner. We have privacy concerns, obviously, as we discussed earlier. Non-law enforcement contacts when you have breaks. if you're in a locker room, in a restroom, for example, with these continuous on cameras, how much privacy are you entitled to when you're on the job but on a break? What about the situation where you're having a conversation with a coworker and make a comment against management or against a supervisor? Someone who walks into a union meeting is another concern. Casual contact with supervisors. Hey, what happened out there? And you make a comment that later on, without consideration for having it being used as a statement against you at some point. We also have the concern of the unrecorded incident. Time or emerging conditions not giving the officer time to engage the equipment. The scenario being you stumble on a crime in progress. You're on a break and you walk into the local Stop and Shop to get a soda or a sandwich, and you walk in on a robbery in progress. And for the safety of the people involved, your safety, perhaps a backup officer, you don't have time to engage that camera and protect yourself and others involved. Defective equipment, as we discussed earlier, the inevitable conspiracy theory, oh, sure, the camera didn't work. And then what additional policies will be put in place that will lead to discipline for the failure to operate the equipment properly or to even engage it. Anecdotally, we're aware of one situation in New Orleans where an officer booked a suspect into the jail, and in the process of doing so, removed the body camera, booked the suspect into jail. There was a limited time left on her shift. Knowing that she was going to check out and go back home, didn't put the body camera back on. Wouldn't have even been able to turn it on because it wasn't on her person. As she's going back to, basically back to the station to sign out for the day, confronts a suspect she knows has a warrant. It ends up in a shooting. The shooting turns out to be justified. Everything else is cleared, but she ends up being disciplined because she did not have the body camera equipment on her person, let alone had the opportunity to turn it on. So this is just yet another example of how an additional piece of technology or equipment, while could assist an officer in the conduct of the duties, can potentially lead to additional disciplinary opportunities for management. You also have routine audits of videos. Are we going to have a situation where management, either well-intended or not, supervisors who go on fishing expeditions to find policy violations in the regular routine audit of these videos once they're downloaded and turned in? What about unreported conduct that's caught on video? One of the things that we've looked at is there's Dr. Bill Lewinsky, who is at the Force Science Institute, who is actually has dedicated his career to the defense of police officers in use of force scenarios as well as investigations, has a few observations about what these cameras are and what their ability to perceive is as compared to the human eye or the human brain. We have different levels of technology available for different equipment. None of them are have the same acuity as the human brain or the human eye. For example, peripheral vision concerns. If an officer catches something out of the peripheral vision or peripheral view of what they're doing, that would not necessarily be caught by a camera. For example, an officer engaged with someone who's in front of them and sees something happens off to the side, which is a potential threat, and turns and reacts to that threat might not necessarily be caught on camera, but will be caught by the officer, and then would have to be explained later on in terms of how did the officer perceive a threat when the camera couldn't. Those danger cues, that there are things that an officer is trained to pick up on, that whether it be demeanor, facial expression, body movement, stance, that are not necessarily depicted on a video or picked up by a camera. Depth of field. There are things that a camera, and we've all seen this, anybody who watches a football game knows when they go to kick that field goal how it can look a mile away when they have the camera behind the kicker, but yet when you show it from the side, it's not that far away. The speed at which things happen. Not all cameras can, it's called a recapture rate. Not all cameras can recapture or refresh at the same rate as others, and certainly your eye and your brain can translate or process information faster than a camera can. Transition from high to low light and vice versa. We've all seen videos where when light conditions suddenly change, that the picture becomes obscured. This could happen because of headlights, flashlights, walking into a room, walking from a dark alley to the street, and vice versa. And all of these things would result in evidence of an officer's reaction being appropriate, not being picked up by a camera. Body parts or objects blocking the view. If you go into a shooting stance in order to defend yourself against a potential threat, will the uniform itself or your upper arm block the camera view? If it's on your lapel or on your chest in some way, if it's in the center body, it could be potentially blocked by the gun itself or your arms as you raise your arms to defend yourself. Time stamping, making sure that those things are accurate and updated. I personally have been involved in cases where the dispatch time has been off or different from the video camera in the car. The time stamp on the two different transmissions is completely different, which could result in a significant difference in the outcome of the case. Angular perspective, which is essentially the same as a peripheral vision. What angle is the camera pointing at compared to the eye? You might be standing facing someone with your head turned and seeing something completely different from the camera picking something up, and therefore resulting in a different course of action that people watching the video would conclude is appropriate. The instant replay second-guessing scenario. The standard for use of force is Graham versus Connor. The officer deems reasonable, not what people sitting in a room looking at a video deemed to be appropriate. The Supreme Court specifically used the words, "We must allow for split-second considerations." Split-second considerations don't exist when you're looking at a video that's been replayed time and time and time again. It's easy to second-guess what somebody has done from the luxury of looking at a video as opposed to someone who is actually out there engaged in the battle. And clearly, the warning should be that a video is not a substitute for a thorough investigation. We can't simply say, oh, we have video, therefore we have all the answers, because of all of these concerns and the things that we're talking about. We must understand and accept that the video has limitations. It cannot be looked at as biblical in terms of veracity and truth. And it's something that we have to be cautioned by, because that's what the public perception is potentially going to be. Someone I have very much respect for as a prosecutor said that we must understand that video is an artifact of technology. And that's what it is. It's an artifact subject to interpretation. Our concerns as the FOP as we go forward into this debate are the always on as opposed to the officer activated, and the various pros and cons of each. Responsibility for damaged equipment. What is going to be the agency's responsibility? And what responsibility are they going to force upon the officer in terms of equipment that gets damaged in the ordinary course of employment or duties? What happens when you have this body camera on your person and you spill your coffee on it? That's not necessarily ordinary course, but we're talking about expensive equipment here. These are things that have to be considered. One of the things that we would push for in any case, whether it be in collective bargaining or certainly if we were talking about drafting policy, is amnesty for self-reporting minor violations. For example, I get into an argument with a citizen that could be interpreted as me probably losing my cool and having said some inappropriate things to someone who got under my skin. If I go to my supervisor and I say, hey, look at the timestamp between noon and 2, and you're going to see that I had a contact with a citizen that ended up being pretty unruly. Take a look at it. I'm turning myself in because you're going to find it anyway. I would think that there would be some amnesty for that, for coming clean. We would certainly want to be able to negotiate that or certainly make that part of policy. Then that enters into the debate of, or the question of, what is a minor violation? How does your department have a disciplinary matrix? Do you have a provision in your policies, your disciplinary policies, that even calls something minor? Is it completely subjective and up to your department's administration as to what's minor? And then how many of those self-reporting amnesty situations do I get? How many bites at the apple? Officer privacy concerns, discussions between officers and investigators. When we first entered into this conversation, the question was raised, well, if an officer is discussing evidence gathering with investigators or detectives, is that something that should be recorded? Is that something that should be kept separate and apart and not on camera? What is the sensitivity of an investigation or the potential for affecting a prosecution down the line when theories of the case are being discussed between detectives or uniformed personnel and detectives? Do non-uniformed personnel, such as detectives or plainclothes officers, have to wear them as well? These are things that we're concerned about. Failing to record, as we discussed before, the intentional failure to record or negligent failure to record in the defective equipment scenario that we discussed earlier. The officer privacy concerns. What happens when you're on break, when you're just having a conversation with a fellow employee, when you're in a restroom, in a locker room, when you're on break and you live within your patrol zone and you go home and have lunch? Are you required to keep that camera on in that scenario? Storage of videos in an uneditable format. If there's an opportunity for an officer to download the video that's been recorded, the video and audio, into a central storage facility such as an online or internet-based storage system, does the officer have access to be able to go back in and look at it? If an officer is being accused of some violation of policy or procedure, should the officer be able to go back in and look at the video before being questioned about their conduct so that they can refresh their recollection as to what actually happened? We would say absolutely. In any case, prior to any questions being asked, that the officer have the opportunity to review his or her own conduct based upon how it was recorded, especially after a critical incident such as a shooting or a car accident or an in-custody injury or death situation, rather than have somebody have the video be reviewed by supervisors or internal affairs or prosecutors and then turn around and use that aha or gotcha moment when an officer is merely going off of memory, as opposed to having the ability to refresh their recollection as to what their own actions were as captured by the video and the audio. Clearly, policies and procedures must be carefully drafted to address all of these concerns. You must look to other jurisdictions. There's no need to reinvent the wheel. It is important to look at what other agencies are doing and how they are dealing with these issues to come up with the most cogent policy and procedure possible. Several cities have already begun using body-worn cameras, and there exists a wide variety of policies. These are just some of the cities that already have body-worn camera policies. The Fraternal Order Police has reviewed all of these. There's been a very good working group that has come together for the FOP that has reviewed these and put together what we consider to be best practices. Clearly, one size does not fit all, and it is impossible to draft a single policy for all agencies, but some models that you would want to consider. The FOP has a proposed best practices policy that's going to be available on FOP.net, if not already, very soon. LRIS has one, and of course IACP has one, but in order to get to the IACP policy, you have to pay a fee or know somebody. In the collective bargaining context, this is a case out of Washington State. It was a PERC case. An employer used a recording from a public safety video camera to discipline an employee, and the ruling was that the disciplinary use of a recording is a mandatory collective bargaining subject because it is a substantial change to employee working conditions. Anything that affects discipline in a collective bargaining scenario is a mandatory subject of bargaining. If video is going to be used, reviewed, and discussed in any way, shape, or form that affects a term and condition of employment, such as discipline, it must be bargained, and the effective use of it must be bargained. And we strongly suggested in those collective bargaining scenarios that you go in and you negotiate how these videos are going to be used. Specifically, those fishing expeditions where they're going to go in and routinely audit them, whether or not the officer gets an opportunity to review them before being questioned, things of this nature. How an officer can operate and what they'll be responsible for in terms of the failure to operate the equipment and the damage to the equipment as time goes on, whether it be because of something that happens in the physical contact with a suspect in the line of duty, or that, as we said, spilling the coffee on the camera. Who's responsible? How they'll be fixed? What does an officer do if going on duty they find that the camera is defective or that something is not working correctly? Will the department supply additional batteries that the officer will be provided with to keep on them so that they can switch them out as time requires? Will the equipment that's being used notify the officer when the battery is going dead? Things of that nature. Clearly, this is a subject of collective bargaining that is limited only by your imagination as to how far you can go and what limitations you can place on them. This is only for illustrative purposes. This was a collective bargaining case involving GPS. And this is something to be very concerned about. The parties' collective bargaining agreement contains a broad management's rights clause that gives the employer the authority to decide all equipment and machinery to use in its operations regardless of the effect on employment. By agreeing to this clause, the union waived its right to bargain over GPS devices, which are either equipment, machinery, or both. The union also waived the right to bargain any effects of the devices, including discipline. So the point being, if you have body-worn cameras that are being introduced to your department, and you have collective bargaining agreement with a strong management's rights clause like this in it, you need to go in and start to try to negotiate how they're going to be used and somehow get around this management's rights provision that could seriously affect how your cameras are going to be used in this particular scenario. So that's sort of it in a nutshell. I wanted to get through it as quickly as possible so that we had opportunity for question and conversation. So at this point, if there are any questions or anything that we can further discuss, now is the time. Do we have any questions, PJ?
We have one that's unique that I don't believe you've addressed directly. Do you see any different issues coming up in different parts of the country? So regional issues?
Not specifically. No, I wouldn't say that there's been any regional difference that we've been able to identify, other than the fact that different policies, some policies from some parts of the country are very lean, not a whole lot in them, and others are very, let's say, all-inclusive. And it really depends upon who's been involved. For example, the New Orleans policy is very, very detailed, and it's most likely because the Department of Justice has been involved. So regionally, I wouldn't say is a focus.
I don't know if you know specifically, but there's a request for thoughts on the Lexipol body-worn camera policy.
I have not reviewed the Lexipol policy. I have seen other Lexipol policies. My concern about Lexipol is it is extremely management friendly. I know folks on both management and union side who have concerns about Lexipol because it's being presented as a universal solution to all problems based upon the way it's drafted, but I find it to be extremely management friendly. I have not specifically reviewed the body-worn camera Lexipol portion of it, but I am not a big fan of Lexipol.
We have another other question. In your review of the policies in place for body-worn cameras, do you find that the majority of departments go the continuous record route, or do they require the officer to activate the camera in specific scenarios?
It's a pretty good mix of both. In fact, they're very, actually that's probably not entirely correct. I think most of the policies that we've seen are not continuous on. Most of them are not. Most of them are officer activated.
We have a specific question about, are there any concerns for corrections use?
Not specifically. I think the concerns are pretty much the same. I wouldn't see. I can't imagine a scenario for corrections that would be any more or less of a concern than the concerns that we've raised. I think the concerns are universal, and I would raise these same issues.
We got an influx of questions, and they're going a bit fast at the moment. I believe you mentioned a policy of, is there one system that you consider best for the officer and management?
We have not evaluated the technology, so I can't. We're not in a position to make that recommendation as far as the systems themselves. If you're talking about the technology itself, if you're talking about instant on or continuous run, meaning officer activated, our preference is for officer activated because of the concerns that we've discussed. But as far as the technology, we're not in a position to evaluate them, and we would rely on the input from the folks who are using them.
Here's an interesting one. How would it affect agencies that have a no recording policy, say, in effect with mutual aid situations?
I'm not sure I understand the question. Could you give me the question again?
How would this affect agencies that have if an agency has a specific no recording policy and they have a mutual aid situation with the department that has body-worn cameras? So the outside party is coming into their no recording policy area. Say, for instance, some federal agencies won't allow recording for operational safety situations.
That's an interesting question. I think that would be something that would have to be resolved through the mutual aid agreement itself. But I would think that any officer that is in a mutual aid situation would be responsible for conduct consistent with their own agency's policies. And I don't think that it would be appropriate for an officer in a neighboring jurisdiction to dictate to an officer coming to their aid how to conduct themselves under their own agency's policy. I don't think that would even be appropriate. But it sounds like that would run into a serious conflict in the mutual aid agreement, which would have to be resolved between the two agencies' administrations.
We have another question. How does, or I'm going to paraphrase a little bit, read it directly. Does this violate any federal wiretap law in regards to recordings inside a home, citizen home?
We're not sure yet. That's one of the questions. We're not sure. We don't know if generally those wiretapping regulations are based upon surreptitious recordings. And if an officer in uniform is wearing a camera, and as we said earlier in the presentation, would the officer be required to tell everyone that they're being recorded? Would the fact that the camera is conspicuously worn on the uniform be sufficient? We don't know. We really don't know at this point. Clearly, there wouldn't be a situation where every time someone talked to someone, they would have to go out and get a warrant. That would be under the operational necessity doctrine, certainly be inappropriate. But what's one of our concerns, as we discussed earlier in the PowerPoint, will officers be required to notify everyone they come into contact with that they're being recorded, especially in those continuous run technology scenarios? We don't know.
I assume that answer also covers HIPAA as well.
I'm not sure where HIPAA comes into any of this. HIPAA is specifically reserved for healthcare providers.
Say if
you have a scenario where you are talking to a supervisor or someone in your agency about a medical condition that is protected by ADA and ADA privacy provisions, and certainly I think you would have an absolute right to turn off any continuous on camera or not record any of those conversations. That would certainly be non-law enforcement. It would certainly would not be evidence gathering, and it would certainly not be public record. So I think that the ADA privacy provisions would clearly protect that conversation, especially since the ADA requires that any medical information that's provided to the employer be reserved specifically to those in the agency who have a business necessity to have that. Even your own direct supervisor is not necessarily entitled to that information. So I think the ADA clearly would protect that scenario.
I believe most of the other questions we're currently getting that we haven't addressed are in regards to the actual physical equipment, types of storage, personal versus employer-provided cameras.
One of the things that we can suggest is we are collecting all of the policies that are available that are being sent to us in a centralized location that will be accessible on our website, and you will have the opportunity to go through all of those policies and see the technology that other agencies are using. Again, we have not been in a position to audit or experiment with any of this technology, so we can't support, endorse, or recommend anything with regard to any of the technology that's available. We just simply do not have the ability to test it or determine, like a consumer report type scenario, as to what is the preferred method. That's going to be a matter of individual agency preference and experimentation on that level. We just don't have the resources to be able to purchase all of these different systems or test them out. We're relying on your input for those, and if any input that anybody has from the field as to their equipment and how it works would be very much welcomed, and we would certainly be willing to collect that data and store it, but we can't offer any opinion as to what's the preferred system to use.
It looks like
our recommendation would be that any system for storing the data be accessible to the officer so that the officer can always review his or her own recordings, especially in the incident where they're going to be questioned about their particular conduct or an incident that occurred on the street that was recorded. We would always want that to be the case.
We have two questions that have come back up again. One, I'll let you address specifically, Mike. It is, as a prosecutor, what would be an effective manner in getting around the broken camera or the camera wasn't on issue raised by the defense? I know the public, i.e. juries, are starting to develop a general distrust for LEO especially when there is no video as to what actually went on.
You know, one of the anecdotal things that I've heard ever since the very popular TV show is the CSI effect. Juries are demanding a standard of evidence that technology simply doesn't support. You know, it's a matter of advocacy. There's, you know, a camera that doesn't work, you know, it simply has to be explained why it didn't work. Juries do inexplicable things. You know, we all know that there are cases that should have been won that were lost and cases that were lost that should have been won. So, you know, it's going to come down to a case-by-case individual advocacy basis. I have, you know, all I can say is how well can you argue the point? You know, it may come down to an expert that testifies that, yes, in fact, there was a camera, but it was defective. It didn't work. You know, I really don't know how to answer the question beyond that.
The next question is, we're coming back to that. It's the HIPAA question again, to an extent. If an officer is interviewing a suspect and paramedics interrupt by asking the suspect about medical history, what happens?
We'd have to look at individual state laws as to whether or not that's protected. I know, for example, in the state of Florida, if you become aware that if a police officer becomes aware that someone is HIV positive and discloses that information, that the officer, by that disclosure, has committed a crime. So there would have to be within that retention scenario a way to protect or segregate or redact that information from the recording. And that would have to be, again, clearly spelled out in policy as to how that information is handled in order to avoid the inevitable conspiracy theory allegation that you've edited this film. So there will certainly have to be some provision in statutes or policies that provide for the redaction of non-public information. And that's something that we've become accustomed to doing in documents. So it would simply be a matter of finding the way to do it through those policies and through the technology for the video recordings.
I'm going to ask for, if anybody's question hasn't been answered yet, or you have something specific, go ahead and ask, type that in now, because we've exhausted the available questions at the moment. Oh, here's one. Do you know of any agency that, after looking into body-worn cameras, decided not to proceed?
Good question. I am not aware of that. That would be helpful if anybody who is listening to the webinar has an answer to that. That'd be great.
And just to clarify, if they have that, they should send it to labor@fop.net, or I'm going to toss mine out there and probably regret it, pjhaley@fop.net. Would that be is that an appropriate email to send the information to, Mike?
Sure.
Okay. Oh, here's one. What about if they switch to body-worn cameras? Do they keep their in-car cameras, or should they go from one or the other?
That's a great question. That's going to be a matter of I'm sure, resources and agency budgets. I personally, because I'm a belt and suspenders person, if it's there to benefit me, I want as much benefit as I can get. I would want both, because you don't know when something's going to get damaged, especially if you're in a fight for your safety, or if something's going to be blocked. As many perspectives as possible. One of my most successful disciplinary arbitrations, we had 5 in-car cameras running all at the same time, and we edited them down to the 2 best perspectives, and it ended up being a very, very useful tool to have as many video perspectives as possible.
Here's an interesting one. How is a body-worn camera any different than a CI wearing a hidden camera with respect to privacy concerns?
Well, there again, it becomes a question of whether or not you're disclosing it to whomever you're in contact with, or the fact that it's conspicuous. These are not necessarily secret recordings to build evidence. These are no different than the car cams that are recording the contact with the citizens. This isn't necessarily investigative as much as it is a record of your contact. So I see this somewhat different. A CI wearing a recording, you probably in those cases have an exclusion in your state law for public records because it's criminal intelligence, number one. And number two, you probably already have warrants and probable cause that have been issued for those investigative purposes, like a wiretap, for example. So it would just come down to how your state law is going to deal with it. And since, again, it's conspicuous, whether or not there's one of the things that probably was left out of the discussion is a citizen, other than probably in their own home, has no expectation of privacy in their contact with police. So if you're in the public forum, on a sidewalk, on the street, or in a police car, There is no expectation of privacy. Your conversation with a public official is not considered to be private. So those concerns are somewhat different. They're certainly diluted.
Different question. What about the videos being used for training purposes?
That's what our preference is. We would expect that if there's an incident that shows that an officer did something inappropriate or incorrectly and either self-reported or it was discovered in an audit, that it be used for training purposes. How the agency handles that in terms of protecting an officer's identity, whether they blot them out or remove the names, would certainly be something you would want to be able to discuss and negotiate. But yes, our preference is that these be used for training, not discipline. Look, nobody does everything correct 100% of the time. People make mistakes. But there's a difference between a good faith mistake and someone who's out there intentionally breaking policy and not performing their job well. So we would certainly want to use these as tools to enhance the profession, not as tools of management to enhance their disciplinary authority.
We have another question along the lines, I'm going to assume along the lines of the wiretap and HIPAA. It's about what about university law enforcement and dealing with students and possible FERPA violations?
So you're going to have to tell me what FERPA is.
I'm going to ask the person who asked that question, if they have an explanation, an acronym, type it in for me, and then we'll come back to that because we have another question we can kind of address as we're waiting for that. What's the
in general? I would not see a university police officer being in any different position than a police officer on the street or going into somebody's home. I would think the policies and the concerns are the same.
And then, what's the difference in a citizen with an iPhone recording an officer or another citizen versus a body-worn camera?
Well, the difference is the citizen is not a government actor. And anything where a citizen, if it's in a public place, a citizen recording something is recording something that's happening in the public. There is no expectation of privacy in the public. If you're on the street, in a police car, in a mall, there is no expectation of privacy, period. Anybody can record anyone at any time. The difference between a citizen recording something and a police officer recording something is the citizen is not responsible for constitutional limitations. The government actor is. But again, if a police officer is recording something that's happening in public, it's no different than a city-mounted camera on a telephone pole. There is no expectation of privacy in public.
We have an explanation for the FERPA. It's Family, Educational Rights, and Privacy Act.
Well, since I don't know what that is,
mm-hmm.
and it's something that sounds specific to a particular jurisdiction, I can't offer an opinion.
Okay.
But again, I think that if you have privacy protections that are in place in a university dorm room, then you would, whatever legal limitations are, would have to be observed in any situation, and the agency is responsible for following that law.
And this one is more of a opinion / assessment. Is, are body-worn cameras going to be a fad, or are they going to continue and get more prevalent?
They're going to get more prevalent. There's absolutely no question about that. In my opinion, like the car cams, they're coming. They're here to stay, and the more agencies that can afford them are going to have them.
There's an interesting one. Should all personnel wear the camera? Patrol versus management.
You know, I certainly wouldn't want management to be wearing them. I certainly wouldn't want them to be on or being worn in the department. It's inside the station house itself. And as I said, there are concerns about the the efficacy of or the efficiency of an investigation when uniformed officers are informing or educating detectives and plainclothes officers about a particular investigation. So there certainly have to be limitations. I certainly wouldn't want management to be wearing them, because the only reason management would be wearing them, especially in the department, would be to be looking for policy violations against department members.
And I believe you've touched on this one, but would a conversation between an individual and an officer inside the individual's home be considered a private conversation if the individual knows the officer is an agent of the state?
Could be. Yes, it very well could be. And in that situation, if the officer is not there based upon probable cause and simply there because they're conducting an interview, or they're there doing a canvass, for example, yeah, I think the citizen would have absolutely every right not only to ask the officer to leave, but certainly to turn the camera off. So yes, that's certainly a concern.
Please repeat the last. Oh, I have to repeat the last question, so this is more for repeating sake. Would a conversation between an individual and an officer inside the individual's home be considered a private conversation if the individual knows the officer is an agent of the state? All right. Having repeated that, what about drones with cameras?
Once again, airspace is public. There's no right to privacy, no different than an officer flying over a highway timing speeders. There is no expectation of privacy in the public, period.
Then I'm going to make another request for any unanswered questions. And other than that, I think we've addressed not all of them, but most of the significant ones. What public record battles have you seen or heard of? Public records, as far as if they're accessible to the public or not.
To date, because this is so new, we haven't seen it. With regard to body-worn cameras, we haven't seen any. Generally speaking, public records battles that we've seen are with regard to officers' private information. For example, in Washington State, there was a huge battle over whether or not public records included driver's license information for police officers. The legislature finally acted and made that non-public information. But with regard to body-worn cameras, we haven't seen, at least I'm not personally aware of any of those fights being waged yet. So the answer is none that we know of to date. We have another question that's a follow-up to that one, as far as it's specifically fishing expeditions by attorneys and the public. Will the footage be randomly requested just because? I don't know. Yeah. I'm sure it will be. Who bears the expense? There will be most likely be treated no differently than police reports. Then I assume that answers the next question of who bears the expense when clips become required for court? Depends upon the rules of procedure and the statutes in any particular jurisdiction. Then with that, I think we've summed up most of the outstanding questions. Mike, if you want to call it at this time. Well, we've gone 70 minutes to this point. If anybody else has anything absolutely pressing that they need to have answered, this is probably a good place to stop. Appreciate everybody's time and attention. Understand that this is so new and so, in a sense, revolutionary that we're working our way through this. We want you to know that we are paying very close attention to this, and we're participating in it to the greatest extent possible everywhere we can. We strongly suggest that you get into the collective bargaining scenario for those who are in collective bargaining, and for those who are not, that you get into your city councils or into your administrative offices and work on these policies and explain these concerns. This is not an easy subject, but you certainly don't want to let the opportunity pass to participate in the policy making and certainly in the contract provisions that are going to affect these issues.